Hi, welcome everyone. Thank you today for joining us. Our today legal services focusing on divorce and legal separation. We have the honor to bring our guest speakers today to go over a couple of topics, mainly to focus on legal services here on campus for our students and what support looks like, and a general overview of our program. Today's collaboration was hosted with the Bruin Resource Center, the Students with Dependents Program, the Underground Scholars Program, and the UCLA um, Student Legal Services. My name is Marita Lopez, and I'm excited to have folks here present. I work closely with the BUS program. For folks joining or slowly joining in, this event is recorded. So if you're unable to make it, we'll be sharing it with all the folks and students at UCLA campus and uploading to our YouTube video. If you're on site and are joining us slowly, please make sure to change your name if you do not want to disclose your name to an alias name. But other than that, I welcome you all, and I'll pass the baton to my peer, Kristen.
Hi, everyone. Thank you for joining us today. I'd like to share a presentation with you all. I don't know if you're able to see it. Can you see that okay? Okay, perfect. So good morning, everyone. Thank you for joining me today. This will be a family law workshop, and we have uh, our esteemed colleagues here, Xochitl Gutierrez, who's been at our office for a year and a half, and she handles wide range of cases, and Jesus Silva Jr., who's been a family law specialist since 2017, and he's been licensed to practice law since 1999. He served as a volunteer mediator and daily settlement officer for LA County Central District and Pasadena courthouses. He has also been a volunteer arbitrator for the LA County Bar Association and has served as a court commissioner for the Napa Superior Court. I want to give you a brief overview of our office. We are located, we're located in Murphy Hall in room A239. We are just around the corner from the financial aid office and across the hall from the CAE. And to give you an overview, Soshi and I will briefly go over the divorce process, and Jesus will go more in depth on topics relating to divorce with dependents and other related topics. We advise students in wide areas of law, including landlord, tenant, criminal, family, immigration, labor and employment, and university-related matters such as student conduct code violations and Title IX cases. All currently enrolled UCLA student is eligible for our services, and we're currently waiving fees for initial consultations, which lasts for about an hour. In a city where attorneys' rates can be as high as $1,000 an hour, we're a very reasonable option, and we are also a confidential resource. So I encourage every one of you to reach out to our office if you have any legal issues that you would like to consult with an attorney about. Um, and this means that any information, because we're a confidential resource, it means that any information that you share with us will remain within the office, and we will not share this information with a third party or the university. So here's a brief overview of our presentation today. For Soshi and my portion of the presentation, we will be talking about the key considerations and the divorce process, the essential terms, the essential forms that you would need to fill out, the service of process, financial disclosures, making decisions, and finalizing a divorce. The key considerations. You have to first understand that California has a 6-month waiting period. So this is a mandatory waiting period. So the fastest a divorce can be granted is 6 months after filing, but for most of the divorce cases, it will take longer. There is also a residency requirement. One of the parties must be a California resident for at least 6 months and a resident of the specific country or county for at least 3 months. There's also a filing fee that you have to consider. It costs between $435 and $450 to file for divorce. but parties can also ask for a fee waiver by filling out FW001. And these are the essential terms. So petitioner is a party who starts the case. Respondent is the other party or other spouse or parent. There's also community property, which refers to anything that you own, or if it's a community property debt, it's what you owe together during marriage. And separate property is property that was acquired before marriage, gifts and inheritances that were possibly given during marriage, property acquired after separation, and property designated as separate property in pre or postnuptial agreements. And the term uncontested refers to parties, situation where parties agree on all matters relating to the divorce. Contested refers to a case where, or cases where parties are not in agreement on some or all matters relating to the divorce. Legal custody, when it comes to child custody, is the legal right and responsibility of a parent, guardian, to make important decisions regarding a child's upbringing, such as education, healthcare, and religion. Physical custody refers to a case where it designates a certain parent for the child to live with. So it refers to who the child actually physically resides with. Child support refers to the amount a court orders a parent to pay for the child's living expenses, and spousal support, the amount a court orders one spouse to pay the other for monthly expenses. And here's where I will pass along the next portion of the presentation to Xochitl.
Thank you, Kristen. And let me just share my screen. If I possibly can do this smoothly. Okay. Perfect. Can everyone see my screen? Okay, great. So some essential forms. Now, these are not all of the forms that will come up in a divorce proceeding, but these are some of the most common ones that you will see. A petition for dissolution of marriage, a summons, those are usually the first two forms that you will have to start a case. The petition outlines what you are seeking, letting the court know information about you, the other party, and your children, and the summons is what gives notice or lets the other party know where they have to go, things like that. When there are children involved, you are also going to have a declaration under uniform child custody that gives information about the children. The fee waiver, I know that there is always a lot of questions about the filing fee and when or how that can be waived if a party can't afford it. So to request that that fee be waived, it would be done through a fee waiver form FW001, and that just lets the court know and information about your financial situation. If you are receiving any type of state benefits, ask questions about that, about the monthly income, about monthly expenses. And that way you can request that the court waive the filing fee. A response is what the party that's not filing or initiating the divorce proceeding, what they would fill out if they want to respond to anything that was in the initial petition. And then I will go into a little bit proof of service and financial disclosures, but those are forms where you're letting the court know when the party, the other spouse, received notice of the case, and also when the parties exchange financial information. The final form that has to be signed or filled out is a judgment. That's what is granting the divorce. Service of process, that is when the other party receives formal notice of the divorce proceedings being filed. To accomplish service of process properly, you have to do personal service, which is an adult not involved in the case must hand copies of the paperwork that has been filed with the court to the other spouse in person. This can usually be done by the local sheriff's department. They have a civil department that can handle service, or a private process server, or if you know someone that is willing, as long as they're an adult, not involved in the case, they could also do that as well. Whoever does it needs to complete one of the forms, the proof of service, outlining where and how and when they served the other party. Personal service has to be accomplished before the case can move forward. The parties have to exchange financial information with each other. Those include tax returns, any documents showing proof of income, any documents showing what you own, what you owe. All of that up-to-date and complete information has to be exchanged amongst the parties. You don't have to file the actual tax returns or pay stubs with the court, but you do have to exchange it amongst yourselves and then just let the court know that you did that. A petitioner, so the party that files the divorce case, has 60 days from the date that they filed to give their financial disclosures. A respondent, the person who was served, has 60 days from the date that they filed a response, if they did that, to exchange the financial disclosures. This is probably the most complex part of a divorce, even though there's only a couple sentences on the screen, but making decisions. Throughout divorce, the parties have to make decisions and reach an agreement as to how to divide any property, debt, custody of the children, spousal support, child support. The parties come to an agreement. You want to have that agreement reduced, or need to have that agreement reduced to writing, signed and notarized. Any parts that the parties cannot come to an agreement, the court can decide for the parties. And finally, finalizing the divorce once everything has been decided, whether that be through the parties on their own or if the court had to make the decisions and has been reduced to writing, all the forms have been filed, the waiting period has passed, the judge can review everything and sign the final judgment. And that's when a divorce and any orders related to custody, child support, and anything else can be finalized. So this was a very quick, very general information overview, and we actually have a one-pager that I will forward to Maritza that can send to anyone that attended with some of this basic information. But now I will pass the baton on to Jesus, our family law expert, who can go more in depth.
Thank you, Xochitl. In looking at your list, I think it was very comprehensive. I think the only document that I would generally add is there's another document called the FL 141, and that's the declaration that the Declaration of Disclosure has indeed actually been filed. And that's because the disclosures are so pivotally important to every divorce. A divorce can actually be overturned and basically set aside if the disclosures weren't done, or if one party comes to the court years later and says, we lied about our disclosures, or I was in the dark about it. So fraud and being able to tell truthfully that you've given the other party notice that everything that we own under the sun has at some point been referenced in a document and provided to the other party is it's paramount. It's super important. So I would add that form FL 141 to your checklist of documents that you need to have. And just before you're ready for judgment, I believe it's form FL 170, which lets the court know that all issues have been taken care of and you're either ready to submit a uncontested judgment where both parties have signed off on it. And by the way, a notary is not necessarily required on an MSA or an agreement. But if it comes from out of state, you can bet that it's better to have it notarized. But if you're within the state of California, as long as the documents are signed originally, that will suffice for the court's purposes. They won't get rejected by any means from the court clerk. but there are many reasons why a court clerk might reject a judgment. So it's always good to have a second set of eyeballs and a personal counsel to take a look at, even if you've come to an agreement. Um, but anyway, I wanted to thank the panel for having me, by the way, here. I know that when I was at Stanford 30 or some years ago, a long time ago, I had an opportunity twice to avail of student legal services, one for a criminal related matter and one for a fender bender. So I just think that it's very important that students have access to legal services when you're at those pivotal ages between 18 and 25, engaged in the academic world and possibly have a very short financial wherewithal to be able to find an attorney and get legal advice. So I know it was so important to me. And so along those lines, thinking that it's important to try to assist the students at UCLA and anybody else who would qualify for the assistance, which I really support. I wanted to try to give a couple of additional notions to people who are here. If there are any questions, or if I begin to ramble, by all means, I'd love a more pointed question. I can give a more particular answer. But first and foremost, everybody should know, of course, legal advice between a client and attorney is only legal advice if there's confidentiality. So there's no confidentiality in a Zoom meeting of this nature. So please keep in mind, I'm not your attorney. I'm not giving legal advice. What I'm giving is my opinion, a legal opinion based upon my over 20 years of experience and having sat on the bench as a subordinate judicial officer for the Napa County, where I was charged with making decisions about family law matters that came up to the bench so that I could decide them. I'm back in private practice now, very happily. But I'd love to share some of my experience with parties that come before the courts to realize how it is that the sausage gets made. And sometimes it is quite that sausage that you don't want to necessarily look at how it gets made. But as someone who's in the realm of it, you want to know, what are the variables? What are the things that I need to know? What's important as far as current law goes, and in the protection of people who, like I said before, are students, generally young, generally, and not having too many resources. They need to be able to try to get things done with regard to a pending relationship, which is come to an end, unfortunately. And whether you're talking about dissolution, the legal, that the state recognizes that the marriage is terminated as a divorce, that's different from a legal separation. And many people confuse the two terms, and they ask me very commonly in private practice, well, should I get a legal separation? Should I get a divorce? Well, it depends on the facts. And if you're a senior citizen, perhaps, and you just want to move away from the other party, perhaps a legal separation is more to your style, because many oftentimes senior citizens don't want to remarry. They don't want to necessarily curtail the benefits that they have within their marriage. So they just want to be able to say, from this day forward, from the time that we file the legal separation, all my future income shall be mine. In other words, or including the debts. So if you go to Las Vegas and you have a terrible gambling addiction, that debt, or your spouse does, you can file a legal separation and you don't have to worry about that potential debt against the community property. So sometimes, even regardless of age, a legal separation where a person just doesn't want to divorce the party, but does want to establish that from this point forward, I do not want to be co-liable as a community would for debts of the household or income. And that is, if you foresee that you've got a lot of income coming in and you feel like sheltering it, again, if you know that it hasn't been earned yet or it's going to be in the future, it would not necessarily be unethical to file a legal separation so that you would limit the amount that you would have to share with the other party. And there's some entanglements in that, but legal separation is there for those purposes. And it's pretty handy. For the most part, most people, when they come to an end of a relationship, they do want a dissolution. They don't want this temporary setup of legal separation. But legal separation has another really useful purpose. As Christin had mentioned earlier, some of the primary essential facts of a divorce is you have to be a resident of the state of California for 6 months before you file, and in the county for 3 months. So you can imagine that if school just started, hypothetically, and you came from a different county, it could be that it's the month of September and you and your spouse have just moved to the West LA campus. You've only been there 2 or 3 weeks. If you had to file an action such as separation, or to ask for child support, to ask for spousal support, or to ask for a domestic violence restraining order, the good news is you don't have to go through the gamut of the dissolution process. What's there for you is the legal separation process. And that's because, again, later on, perhaps you want to get a divorce, but for now, the most important thing is you don't want to have to wait 3 months and live in the county. You don't want to have to wait and be in the state of California for 6 months. What you can do with the legal separation is file immediately. And that's generally because people tend to move around. And if they do, they don't necessarily want parties to have to wait months before they can file a request for a restraining order, which might be a life and death scenario. So when it's important also with regard to getting child support rolling because the parties have physically separated and somebody might be dependent upon the other party's income, it's very paramount to make sure that the party files legal separation, that they file their motion at the same time or very soon as they can get their ducks in a row to get spousal support, child support, any other things that they think are emergency based. The court has that venue, and that's the way the opportunity to make sure you can get into court immediately. And then later on, should you wish to proceed further, of course, you can always file for divorce later on. But keep in mind, it's literally a separate action. You can't just stay on your legal separation petition and convert that to a divorce. It doesn't happen that way. All respondents are entitled to know now my spouse is asking for not a legal separation, but a divorce, and that will require an additional 6-month waiting period. So it's correct. Nobody can get divorced in less than 6 months from the time that you start to the time that you end. That's a mandatory statutory waiting period. And that's because it takes about that long just to get all the various ducks in a row to make sure that people have got their separate property, their income set up, and had an opportunity to resolve all the issues that could come up. And yes, indeed, 6 months is actually relatively quick. More commonly, a divorce will take about a year to a year and a half. It should, barring unusual circumstances. Keep in mind, a year and a half to 2 years is too long to work through a divorce. I recently, I'm in the process right now of doing a 5-year divorce, and they're into their 6th year. And I can't tell you the amount of emotional luggage that has occurred because of that 5 to 6 year period. So there's a reason why their timelines are kind of tight and they're designed to push people along gently, but at the same time, not to push it too fast because it does take a time for people to make the proper disclosures, to possibly do the research to just say, hey, I agree with this figure or I don't agree with this alleged figure for the value of our house, the value of our business, the value of property that might be out of state or something that we bought during the period of marriage. So it takes a while and it warrants careful review. So it should be done in nothing less than 6 months, but don't be surprised if your typical divorce lasts about a year to a year and a half. More than that, and you probably have got a reason for stalling and something's funny about it, but a lot of times the facts dictate that. And sometimes that's about the children being particular tender ages. Sometimes people want the children to age out of grammar school or middle school or even high school before they decide to pull the trigger on something as permanent as divorce. So sometimes that will slow things down. But at least the important part is from the time that the petitioner files the petition, there are going to be automatic family law restraining orders, which prevents them from, for example, going out and spending the money of the account community. They are immediately barred from taking any sort of action which the other person would normally have consent to in order for it to happen. Otherwise, those types of transfers can be undone. And there's a penalty for that. So, and as for the responding party, it's effective. Those automatic family law restraining orders are effective the moment that they've been served. So service of process is really important because the petition is only fair and square if the person has received it and has an opportunity to review it and respond to. As was mentioned before, there's a limited time to respond to that, and it's important to do that. But in that interim period, there could be other things that are taking place, like namely motions for child support and spousal support. While the divorce can take 6 months, many times when a petition is filed for legal separation or divorce, simultaneously, concurrently, one will file an RFO, which is called a request for orders. In the past, they were called order to show causes or different things, but it's a motion. Like anything else in civil court, it would be called a motion. But the request for order is, in layman's terms, an attempt to let the public know if you want an order, you request it to our California judges, and you put your allegation, your factual acts that you believe will support your allegation, and you submit them to the court. The other party has an opportunity to respond, there'll be a court date. And in every motion or RFO, as soon as you file, you're going to ask for a court date. And that's probably going to be 4 to 6 weeks out in the future. It could be as short as 3 weeks, but keep in mind a party has a right to receive that document 16 court days before the motion. So again, it's fair on both sides. It's designed to give the respondent an opportunity to respond. And it's fair for them very often to ask for a continuance and say, I just showed up, I haven't even hired an attorney. So that can be pushed back. And a motion request for spousal and child support and child custody, super important, the custody of children, might sometimes take 2 to 4 months to even be heard, because remember, somebody's asked for a continuance and they might get a good reason, might be able to give a good reason for that and receive it by a court. So keep in mind, it's important to try to get these requests in as soon as possible, because people want to be civil in courts and give continuances where they're able to, where they sound reasonable. No judge necessarily wants to have justice by surprise. Justice by surprise doesn't help in family law courts. It's in general, most judges, and the trend of California is to make sure that everybody gets a chance to be heard in court, and that we don't win cases by squeezing people out of court or tricking them into believing that they've got more time to respond when they've been timed out. Courts are generally liberal with regard to those types of extensions of time or deadlines, unlike in civil court. In civil case, if your statute of limitations is gone, it has flown, for the most part, in my experience. In a civil case, deadlines are true drop-dead deadlines. In family law, there's a lot of discretion, because judges in family law run by the general rule of being a discretionary court. These are courts where there is a margin of error for the judge to have wiggle room. And that discretion allows them to work, essentially, and listen to the facts. So keep in mind that many times clients will come to me and complain about, well, we've already passed this deadline. The other person should have responded within 30 days or 60 days, and they haven't. Keep in mind, it's not over until a judgment has occurred, actually. You cannot count on drop-dead deadlines in family law to squeeze the other person out of justice. There's so many ways to come back into court, even after you've missed a deadline, 6 months, a year down the line. There are ways to come back and say, Your Honor, this is such an important factor in our divorce or family that we're going to ask for and excuse ourselves for being late. More often than not, you'll find that judges will allow it. And the appellate courts have basically backed that up to say that the judges have the discretion to relieve parties who have missed deadlines. So I'm not suggesting that anybody miss a deadline, certainly, but if the other party has missed one, it's not lock stop. It's not necessarily over until you actually get a judgment. Judgments tend to be a lot more permanent in those cases. So I just wanted initially every party out there who's considering or contemplating a divorce or trying to figure out how to file to know that, yes, you can file for divorce with certain limitations. You can file for legal separation much faster. And concurrent with that, tag on, to that, your request for orders for everything under the sun that you can think about, from the other party misspending financial accounts or needing access to a certain vehicle because you have to use that car for work, or access to your telephone. Sometimes things get so bad that parties will steal each other's ability to communicate. So you'd be amazed what happens behind closed doors. So many of these things come also at the end of a relationship. Domestic violence and the allegations of domestic violence are something that parties often want to hear about privately in consultation, to ask whether or not the facts that they were exposed to would provide them a rationale to ask for a restraining order and get it. Keep in mind that restraining orders are done on the basis, the burden of proof is a preponderance of the evidence. That means that you're going to convince a judge more likely than not. It's 50.1% versus 49.9%, but the judge believes it to be the case. It's not beyond the reasonable doubt. It's not, with some other level of certain evidence. It's just a preponderance of the evidence. So it just means that that's the burden that any moving party needs to show in order to get a court to make a finding. The findings are based upon whoever shows the better evidence, the more accurate evidence, the more credible evidence, perhaps. But what wins the game in court is to try to show the preponderance of the evidence. And that applies within the aspect of trying to prove that one is a victim of domestic violence. And I've been doing this now for about 25 years, since 1999. And in those 25 years, you can imagine that bar that has moved quite a bit. And part of that is because family law is a lot about culturally what parties are thinking about here and now. And so it changes and it evolves and devolves over periods of time based upon what the culture is. And all family law across all 50 states is done on a state by state by state basis. There is no federal law that is an umbrella over the top of it. Almost all family law decisions are done by state. And that's why it's so important that you go to the proper state. I'm licensed in both California and Nevada, so I've had an inordinate amount of questions about to which state do we file in. And there can be some real tricks if you've got one party in one state and the other party in the other state. And so you want to verify that you actually in the right court make that decision. But ultimately, the state that you file in has super important ramifications because, as I said, every state determines its family laws differently. For example, child support in the state of Nevada, where I'm licensed, might be, for example, a higher paying party. There's going to be a cap on this child support. If they have two children, you're going to add 2% to it. So suddenly child support that was 25% of the higher income party's income is going to be for two children, 27%, for three children, 29%, for four children, 31%. See, the pattern just goes up 2% per child up until a certain amount. But in the state of California, it's done completely different. It has, yes, the number of children matters, but it's not so simple as just adding on 2% for every child. The formula in California is one of the most complex of all 50 states. And it almost takes legal counsel to try to understand how it is that child support is calculated. But it's about actual earning capacity of one parent versus the earning capacity of the parent, and then the percentage of physical custody. And it's a very important component because, for example, in the state of Nevada, percentage of physical custody has no effect. So whether you share a child in Nevada 50-50 or have 90% custody and 10%, the child support amount in Nevada is going to be the same number. It does not matter the quantity of child custody. But in California, physical custody quantity is so important that one will pay more child support if you're the non-custodial parent and you have less amount. If you only got 10%, you're going to pay some amount. If you only got 5% or 2% of physical custody, you're going to pay even more. So what that does, unfortunately, is it allows California residents to game the system sometimes unethically to fight first for child custody because they know that the more custody they have, the more child support they'll earn via the formula, the complex formula. Whereas in states like Nevada, that's not a factor. You don't get more money because you get more physical custody time. And there are various points of perspective as to why one state would choose this system versus the other. And each system has benefits and disadvantages. But being here in California, I wanted anybody who's filing in California to realize it's so important where you file because the state's laws are different and they're designed quite different. You have the different effects. So you can get quite various different results in different states, given the same factual circumstances. So it's something to keep in mind. And as I was talking about that over the 20 years of the time that I've watched this culture movement go, one of the things that tends to show that as a great example is the right to same-sex marriage, for example. When I started out in 1999, at that point, same-sex marriages could not exist in California. So in about 2004, the state of California started doing something called registered domestic partnerships. I don't know if anybody remembers these RDPs, but they were quite common as a way for California to analogize a civil union that was happening in some other states who were equally progressive in allowing same-sex marriages to be recognized by the state via what's called a civil union. So California didn't have a civil union, but they started up this act that was called the Registered Domestic Partnership Act, and it allowed California to have exclusive ability to create these marriage-like institutions and to terminate them. That meant even if both parties went off, and I had a case where both parties lived in China, but they came back to California because they had to divorce, they had to terminate their RDP because California was the only place that had proper jurisdiction. It was a California designed and created instrument, and it could only be terminated by California purposes. However, let's move the clock forward. Keep in mind there was pushback toward the civil unions. And in 2006 or 8, California actually voted to ban same-sex marriage, and they codified it right into the Constitution. And that came as a surprise to many people who are more liberally minded and progressive in California and thought, wow, that runs counter to the general trend. And that was the state of law for a little bit until about 2 years later when the Ninth Circuit decided that that was unconstitutional for equal rights purposes. And ultimately, that law, Proposition 8, which went into effect in about 2006, was only overturned a handful of days ago. In the November 6th election, one of the things that was won was removing that prohibition, although in practice it had already been removed. But it was finally pulled out, and you'll recall that one of the propositions that was put and successfully passed was the ability for people to marry regardless of their gender, who they wanted to. So that's how the needle has sort of moved just with regard to same-sex marriages being disallowed and then being reallowed through the courts, through people fighting one case at a time. Ultimately, there was a big federal case, the Obergefell v. Hodges case in 2015, which most people will now remember as basically saying that it was unconstitutional, or that there was disparate treatment between the states in the manner in which they were determining that some parties were able to get, I think it was a domestic registered partnership, which was the case, which started the facts behind the Obergefell case. And the way that they were treated differently by the IRS, that the tax code had treated parties differently for RDPs as they had for divorces. And because of that difference, the courts ultimately said that it was that same-sex marriages would be permitted in all 50 states as a result of that. So then, of course, it comes back to the people who had the ability to codify it by state. But in the interim, that was a major moment for people who culturally were engaged and wanted to make sure that people could avail of same-sex marriages over this 20-year period that it seemed to come and go and come and go. And rights like that, I mentioned that as an example because there are aspects of family law which have also continued to evolve over that same period. When I came into the business in 1999, when more often to show domestic violence, you had to show true factors such as I was hurt, I was assaulted, or at least I thought there was apprehension that I was about to get punched. I thought I was about to get hit. You had to at least show that there was genuine violence of some sort of physical contact. Like the evolution of other family law matters. In more recent times, the courts have progressively evolved to show that a victim of domestic violence doesn't necessarily have to show domestic, true physical contact anymore. Non-physical means of violence do exist, and they have finally floated on a case-by-case basis without being codified. What does exist is case law in California, and I think that really started with the Ned Carney case, in re marriage of Ned Carney. That was a case about somebody who was being stalked by their husband, by their spouse, via electronic mail. And I think the other person had tapped in because they knew into the other person's email because they knew the password. And they thought, well, if I know the password, if I can determine it, it's not immoral and it's not harassing. But indeed, the courts found that you do have a general right to a reasonable expectation of privacy in some aspects, such as your email, and that you can be electronically surveilled to the point of feeling, I am not comfortable with this person's ability to follow me, to stalk me, to trace me, and yet they're only doing it electronically, and there's nothing physical about it. The courts have said, and in cases like that now, the law generally, the status of parties need to know is you can harass somebody to the point of non-physical violence, and you will get a restraining order against you if you're not careful. And if you're a victim of that, know that those are within your rights. You don't necessarily have to be pushed, prevented from leaving your house. It could just be that your spouse is curtailing your ability to have relations with your own family members. That is, they won't let you talk on the phone, or I've seen cases where parties are prohibited from utilizing an ATM card. So they are financially restrained. So if they've had their neighborhood and families contacts forbidden from them, if they've had their financial abilities forbidden from them, these are all non-physically invasive ways that a spouse can abuse the other person and force them to do things that they wouldn't necessarily do just by duress, by pressure. So keep in mind that the laws that existed 20 years ago with regard to what is violent and what is not violent have changed. And those will always continue to change. If these family law values have changed just in the 20, 25 years that I've been a practicing attorney, I'm sure over the next 25 years, there's also going to be future change. So if you're a younger student listening to this, keep in mind that the laws are going to probably evolve. And it's always good to have good counsel which can coach you and help you to get through those and figure out, okay, what are today's bellwether facts? What are the current cases that can show whether or not this is slightly violent or just not violent enough to get a restraining order? And restraining orders have major consequences. I talk about it because in the Code of California, if you're determined to have been a violent person or the primary aggressor, you will have a presumptive finding by the court that joint legal custody of children, that is, I'm sorry, joint physical custody is not in the best interest of the child. So a court can presume that if you've been violent, even non-physically violent against a spouse, a parent of a child, that the same might be already applying to a child, a minor. So the courts have given the children the ability to, a parent to argue on behalf of their child, some of these same things that a spouse would have a hard time articulating, a child could as well. So keep that in mind. Um, and one other thing I want to talk about, when we talk about the evolution of family law over the past 25 years, another major point of contention that still doesn't exist yet necessarily in other states, but is existing finally in California, is the notion of more than two parents having legal custodial rights. Very rare. And even though it's been enacted now and codified, I think in 2014, so it's been in place almost 10 years now, before that, you could not have more than two people who would come before the court and say, I'm the person most involved in the child's life. I'm the person who should have the best interest of the child and have that power. So before that, even though there were scenarios where somebody could have three people in their lives who had all held these same, more or less authoritative capacities, there was no law that could support it. And the courts had their hands tied and they could only provide that power to two people. Now they have the ability to do as much as perhaps ideally, hypothetically more than two, three, possibly four. I have not seen those facts, but hypothetically, you could petition to the court to say, I was an uncle or neighbor or a lover of one of the parties, and I co-raised these children, and they have such a bond with me that we're so close. It's, maybe we're not parent and child, but it's like a parent-child, not unlike a presumed parent where I've held out this party like my child to other people. So you get the benefit of, if you're going to hold the child out as your own, very often a court will say, well, then you're the presumptive parent, even if we don't have a guardianship in place. Courts, keep in mind, have to make very quick decisions sometimes about who can actually be empowered to make decisions over a child. And sometimes it's really difficult when two, let alone three people come before the court and say, no, I'm the one that knows the child the best. I'm the one who, took them to doctor's visits, to school, and can tell you on their developmental stages, day by day, what they're into, whether they're spelling their name correctly or just, learning the alphabet. So it's important to have somebody who knows the day-to-day developmental stages of a child. And sometimes those are the factors that courts will look at. If it wasn't obvious, if it hasn't been known to all people, but the courts for a child custody matter, it's the best interest of the child. And I've had 1,001 people, and certainly people are never going to stop asking me, what is that, Jesus? What is the best interest? It begs the question. It's such an anomalous, ambiguous phrase that it really allows you to throw everything in the kitchen sink into what one particular parent thinks is important to the child. And that level of wiggle room is nice because from a litigator's perspective, when you need show the court, when it's not black and white terms as to who the parent is or who they lived with, or maybe a child went from grandparents' house to an uncle's house to a neighbor's house before they finally settled in. It's tough sometimes to know who you're going to respect, who you're going to give that permission to take custody, physical custody of a child, let alone legal custody. Like I said, there are two different issues, and one of them just talks about the power to enroll them in education, health-related things, school-related things, sometimes religious-related institutions. But the other one is about physical custody and the sharing component, which like I said before, in California, has major ramifications with regard to child support. They're intimately connected, whereas in other states they're not. So these things tend to dovetail into each other, whether or not, there was violence in the past in the relationship, whether or not it's maybe not even a factor. Maybe there were, like many divorces, simply disputes, simple arguments, and there was no nonviolent, coercive behavior. And by the way, that's the latest term coming into domestic violence cases. The Domestic Violence Protection Act has recently allowed in California cases allowing coercive control. So that's the latest term that attorneys are tied up about. It's like, well, what's coercive control? What does it mean to coerce somebody into doing something that they didn't want to do? You can imagine that runs the gamut, and you're going to make those arguments in both directions. So these are some of the ways that California law is continuing to evolve, and why it's so important for parties to have a good opportunity to consult with an attorney to try to work out, what are my facts? What is the current state of law? And how might that help me to get what my goal is? If whether or not sometimes it's legal custody because you don't trust how the other parent might or might not take the child to the doctor or to education or health related issues or school related. Or sometimes it's about, just like I said, not legal custody. You trust the other parent. You're willing to share all power with regard to out of state visits or things of that nature. But it's about custody, physical custody, because one party lives closer to the school or has bought a home that's just within walking distance to a grammar school where the kids are enrolled hypothetically, or a high school or a middle school. Logistics so often win the day in court. When we talk about what's in the best interest of the child, in a true custody battle, so often logistics, like location, is so important. And I often tell that to my clients until they're tired of me hearing about the fact that it's about what logically makes sense. Where do the parents work? How often do they work? What type of work do they do? Are they the bosses? Are they employees? Do they have flexibility in their working hours? Do they work from home? What is the general state of health of the parties? And keep in mind, there's no reason why just because somebody's in a wheelchair that they're going to be at a disadvantage to being a better parent. And there was a case behind that almost over 20 years ago, which was very important at the time for people who were disabled and needed to be able to show to the court that they were just as great a parent as the other parent, despite physical disabilities. But all sorts of factors come into child custody battles. And very often, when it comes to a divorce or a separation, what has physically happened is somebody is picking up, moving their stuff out, and relocating. So the notion of a move away becomes really important. And because I was licensed in both California and Nevada, I saw a huge number of, a lot of my cases were move away cases. And some of them were actually between California and Nevada. Some of them were between California and Italy, California and Ohio, California, and you name it. Because the child had lived in California, so the California courts had jurisdiction. But there are statutes which cover international cases. People probably heard of the Hague Convention. The Hague Convention is an international treaty that works not unlike the state-by-state rules that provide here, so that you can figure out how a child custody battle will go at the international level. But at the state level, one thing I did mention that all 50 states do child custody and child support slightly different. One thing that's great, in the 25 years that I've been practicing, when I started off, not all states complied with what we mentioned earlier, which is the Unified Child Custody Jurisdiction Enforcement Act. The UCCJEA is California's long-winded way of saying we have jurisdiction over the child and that this court battle will take place here in California. So pursuant to the UCCJEA, That's California wants to look, where does the child live for the last 6 months? Now, finally, in my 25 years of practice, all 50 states have finally enacted something analogous to the UCCJ, the model code. So all 50 states now are running by the same rules. Individually, they have all prescribed to it as they needed to. But it wasn't always the case. But so the nice thing is between the states, there is a mechanism, there is a test that's tried and true as to which state, a child custody battle should be held in. Because there's a slight advantage to having the custody battle held in the state of the parent that would like to argue that this is the better place. More contacts exist here, familiarity for the child and a parent exist here. They want to show connections to the state and the local forum. But a move away case is very, very common, very important. And in California, there are about 8 factors as to why a parent can actually move away and take a child. Yes, in this is a free country. Make no mistake. It's a red, white, and blue free country. You're able to move anywhere you'd like in this United States. But if you've got a child, you are not. You are not. And if you're in a divorce, that is, if you're getting a divorce, separating, and you do not have freedom of mobility, that has gone away because the courts ultimately have the power to control the physical ability of where the children will be, at least until a court judgment has been held. So it's not a free world, and it's not a free country, and you're not able to just take the children to Tennessee if you think that you can strong arm the situation, because within 6 months, the left behind parent could file a petition saying, this is where the child used to live, and the other parent took them to Tennessee, for example, without my permission or consent, and they did that 5 months and 3 weeks ago, so I'm just barely in time to make the deadline. And that's a pretty firm deadline, but you might not get a court to extend that period of time without showing a fraud. But yeah, you want to make sure that you can fight for this to be the home state if that's the case. If you're in a circumstance such as that, there is law which provides every child to be within their home state before they have to possibly reach a judgment. So it's a rule of law that I definitely agree with, and I think is extremely useful to know that a parent can't just move far away to Northern California or to another place and take the child by force. A force in a scenario like that does happen, can happen, and sometimes in unusual circumstances, I've advised clients that you might want to do that only because we think the other parent is going to be a non-active parent or a parent that just doesn't care. And you think that you can wait it out 6 months and then file in the other state or the other jurisdiction or county, knock yourself out. It could happen. But in general, you need to know that those are the deadlines and that all 50 states prescribe to them by now, which is very helpful in trying to relocate and get back a child when somebody has taken the law into their own hands. And a move away case, by the way, the very first case I almost ever litigated and lost was a move away case. And it was only over about a 45-mile move. I had a client, they were in Southern California, and it was a terrible case. And I suffered about it on her behalf for many years, thinking, what could we have done differently, argued differently, because the results were just, in Southern California, LA, in such a huge metropolitan area, if you move 45 miles away, the difference between West LA and living down at Dana Point is, well, maybe that's only an hour, but that's an hour and a half commute. And to take a child back and forth can be 3 hours, right? So a small perceptive period of miles of, I'm only going to move, Your Honor, 35 miles up the road because I've got a better job or I'm going to live with my parents. You're going to have to throw everything and the kitchen sink into those arguments and make sure that you hit those 8 points that a move away case determines to be factors. Because even a move of 35, in that case, it was a 45-mile move that I lost. So it hurt my client very, very much, and she suffered for years. But if we had done things differently, I would have. But you're left with that years later. Every time you lose a case like that, you realize, wow, how close these decisions are, but yet how huge the ramifications are, how long-term lasting some of these things are. So that's just a little bit of an overview of, I think, what are some of the really important things that if I were in a relationship and I had children and there had been any sort of borderline domestic violence, and any movement among the parties from one household to another, from one county to another, sometimes dealing with the fact that I'm a student and I came here to be a student. This is temporary. I intend to go back to where I was before. Keep in mind, those are arguments that the court could have to hear about as well. So permanence and long-term scenarios, facts really matter in a lot of these requests to the court. Before you ever ask for child and spousal support, you should always make sure that you've had a heart-to-heart consultation with somebody that you trust, who's a family lawyer, hopefully who's a specialist, who's done enough of family law, because it's highly nuanced. It's very tricky in some regards. So you want to make sure that you're getting the best legal advice you can, because the issues that touch family law are, to me, something that has never made family law a boring day in my life. It gets me out of bed because these issues are heart string pulling issues. They matter to people. They're the people that they fall in love with, the children that they bear, the savings that we every day 9 to 5 work for. When these things are at risk, they're the most important things on the planet to everybody. And I think that's, to me, why family law is so compelling, so interesting, and something that really needs to be looked at very carefully, because the ramifications span generations. And we don't have enough time, but I have many stories about how legal actions, divorces that took place in the 80s still have fallout in the 20th, 21st century. And it affects people. How they saw divorce affects their way of handling their marriages in the future. And considering the facts that during my lifetime, for the most part, divorce has gone up quite a bit into the 70s, but after that has pretty much stabilized. But in general, 50% of all relationships ultimately come to an end. And that's the stats, that it hasn't moved in about 20 years or so, despite the various movements of cultural dynamics. In general, still, 50% of marriages don't work. And that means that if you've got 2 children, one of them is probably going to go through a divorce. So I try to tell my clients, we need to begin modeling great behavior right now, because your children are part and parcel of this divorce, whether they're 4 years old or 14 or 24, already of majority age. And how you handle yourself during that divorce, if you've got 2 children, there's a coin flip of a chance one of them is going to be going through the exact same feelings that you're going through today. So I let them know, we need to role model this behavior. You got to think about where is this going to put your child in 20 to 40 years when their marriage is falling apart. They're going to think, how did my parents go through this? What affected me negatively? What affected me positively? What is it that one parent did that made the divorce livable, survivable? So I ask my clients very carefully before they do anything, think about the 20 to 40 year aspect of this termination of a marriage, what you thought was the most wonderful and beautiful thing in the world, which is now, how can you live and keep your dignity intact and your child's chin up? How do you keep your chin up and your own child from becoming a negatively tainted person? Because people do, they remember their parents' divorces when they're going through a divorce. And I see it in private consultations, so I know it's a fact. I know that every divorce that happens today has ramifications 20, 30, 40 years into the future that we have no way of knowing about. So I hope that I've touched on a couple of things. There was one other thing that I noted down just this morning that I thought might be interesting to students in particular, because with regard to students and student loans, an issue which is, especially if you've been married and you were in college, you probably took out student loans like many people do. The family law code basically says that if they were taken out during marriage, it's a community debt, and that the debt has to be shared by both parties. However, California has a special code, a special exception to that rule, which basically says that if the parties are divorcing, the courts are supposed to look at who borrowed the money. And 9 times out of 10, in my experience, they will, counter to the community property debt rules, they'll actually assign that debt to the parent who got the education. So that's an outlier, and that it's an exception to the general exception. So keep that in mind. I think that's important for students to know. If you've married and you're in college, you've probably gained student loans, you borrowed monies as a community, the community has benefited it. So it definitely makes sure that it makes sense that it's a community debt. But alternatively, you can bet that upon divorce, when push comes to shove, if you litigate the issue, the courts will probably assign that debt individually to the person who who benefited from it first and foremost, primarily. Now, keep in mind, if it's 20 years after if your marriages last a long time, and if the person was a professional doctor or a high-paying physician or something, it could be that their education and the loan already allowed the marriage to live to a higher standard. So there are arguments to be made in both directions that that perhaps the community has already benefited from the student loans. There are also arguments to state that we just got out of school and we haven't even gotten into the workforce. Maybe their income is going to be like that in the future, but right now all we know is debt, and so it needs to be shared and assigned properly. So a couple of particular rules that will affect students who borrowed tons of money due to student loans differently. So something to keep in mind as well. And if in talking, if I raised up anybody's questions or anything anything that I might be able to provide more specific details, so I'd love to. I just don't know if I've got run over my time or if that's too much detail.
Thank you, Jesus. This
So I'll pause for
was,
a moment to give a chance to any questions.
yeah, this is so very helpful and so in depth. I know our students are greatly going to appreciate this information. I do have a question for folks who are undocumented, and I know that can be very complex, but for those that may be either dual undocumented and have citizen children, or maybe one of the spouses is undocumented and one is a citizen, what does it look like as far as filing divorce or separation and child custody?
That's a great case. That's a great question. That is, because sometimes a person's status in the country you would imagine, have be a factor in a child custody dispute. But in general, the courts are kind of loath to want to look at a person's custody status because, well, I'm married to an immigration specialist attorney. I know how difficult it is to give anybody strict advice that yes, you're going to be deported, or if you are, it's going to be at a certain date. People are here for different reasons, and sometimes they're eligible for temporary protected status, and sometimes, based upon the administration, that can be removed. And so, if you were from Cuba or another country that had a different immigration rule, maybe it's not going to be what you thought it was, or when it's going to be applied. It's very difficult to know when. So even if people are undocumented, the family law courts aren't going to say, well, you're here out of status, even if the other party says, I know that my spouse is here illegally. The family law courts have no enforcement mechanism to say, okay, let's go get the Homeland Security to escort this person back to whatever home country they belong to. There is no connection. The court's going to have to make that decision, knowing that, okay, so this is a factor. One party here is alleging, and the other party might dispute it, but might not have an argument against it. But there's an allegation that one party is here in the country unlawfully. Now, the judge is going to probably have to figure out, is that going to factor into child custody based upon the particular ages of the children here in this particular case? Sometimes it will, sometimes it won't. Particularly if the children are already 16, 17 years old, even if a parent gets deported, a minor child that age is not going to leave the country with them 9 times out of 10. Just logistically, it's probably not going to happen. But if they're younger, if it might be the mother and there's a bond between the mother and child, maybe a mother who has to face a deportation order with a 5-year-old or a 3-year-old might want to take that child, and that happens. And then sometimes it's for the other party to make sure that, wait a minute, if I've got legal status here, I want to make sure the child will stay here. So it can be used sometimes as a weapon, as a sword against a person, but it's hard to, because enforcement of immigration is so difficult to predict unless somebody's actually had a deportation order. And I've just never been in courts to represent somebody who said, oh, my husband or wife has already been ordered to leave the country. And so it's a matter of days. Maybe that would change things. And definitely that would be a relevant factor. But by and large, the courts are going to look at parents as to like anybody. They're going to look at them without looking at their legal status, try to, and just ask the germane more questions about logistics that we talked about. Do you have a job here? Do you work? Where do you live? What's your income? You have a relationship with the child. The child is bonded to you. Look at the typical factors and then leave it up to the powers that be as to whether or not they might actually have to leave the country and give up custody of the child, or consider taking the child with them if the factors dictate that it might be good for the child. So it's a great question because sometimes it comes into play depending on where you are in immigration status. And sometimes it has no effect whatsoever, despite the fact that your instincts might tell you this is a major factor. And if you're a parent on the other side, you might think, well, I want to like use this as a sword or as a shield, to let the courts know if and when the government deports me, then I'll leave. But until then, my number one job and priority is raising my children. And if you make that point clear to the courts, I think that the courts are going to say, well, then subject to the mercy of what happens to you immigration wise, while you're here, my ruling is, that you're going to have this amount of custody, and it could include legal custody. It's not going to necessarily dissipate simply because you're not a national of this country. In fact, many people don't have to be nationals, and they're still going to fight for custody issues, even if they have to come on visit or tourist basis for 3 months at a time, 6 months at a time, whatever. The one way that people share custody of kids is to ship the kids internationally or interstate, and that is a solution, which very often is the only solution for trying to share babies. As you know, as the notion goes, you can't cut the baby. It's whoever wants the baby to stay intact and can present a plan to the court that I can share this precious gift with the other parent, perhaps better than the other parent can share this precious gift with me. And I'm the one who has the mentality to make sure that this child has and facilitates a bond between child and faraway parent, whether that's the parent who lives 100 miles away, 45 miles away, or 4,000 miles away, 12 hours away on another plane. Sometimes those are major important factors.
Thank you so much. And then one last question. So for our students, so I didn't actually get a chance to introduce myself as well. I'm Aisha Bras, the program director for the Students with Dependents program. And a question is, so many of our students, of course, are low income. They are looking to get legal advice. And so if they were to go to legal services, you all do provide resources for them to outsource and connect with low income services.
Yes, we can certainly do that. We have a list of community resources that are available to the students. I think Jesus's rates are a little bit too high for our students. He's so very well experienced. We can go to him for questions that are in depth, but we do have community resources available. There is also a mediation clinic available through UCLA Law School where they help students reach a resolution and an agreement before filing. And it's free of charge, and they provided it to students and non-students. So I think that is also a great resource, and we can connect students to all of those resources that are available.
And Isha, to piggyback onto that as well, mediation is by far one of the best ways to try to resolve issues of family law when there are disputes. And it's something that can't be said enough because there's no, I'm also an arbitrator, but there's no notion of arbitration yet in family law. There's a bit of a movement toward that. But generally, private judging doesn't really happen. But mediating is not unlike having a private judge. That is just somebody who the parties think is neutral, who is unbiased, who knows the typical variables that a judge, if it goes to litigation, would be looking at and can tell you with a straight face, I think I know this judge, and I think that they tend to rule spousal support in this manner or child support in this manner, because judges have their own senses of patterns. And so it's nice if you've got a mediator that has some experience in that courthouse or you're at. But all family law matters have a demand that everybody meet and confer with the other party before you take an issue to the court. You've got to meet and confer. You have to have a dialogue. You've got to be able to communicate what my issues are, what are my alleged facts to support those issues, and why I think it's in the best interest of the child for this to happen as opposed to this to happen. So mediation is the best way to try to resolve all family law disputes. And as I tell people, I'm also a long-term mediator. And one of the first things I tell people when they come to mediate before me is congratulations that they've come to an area where, when you look at divorces that occurred 20 years ago and you give them surveys and you tell them, was your divorce done by mediation or was it done by a judge? And then you divide the two parties up and say, okay, if it was mediated and you had your hand in putting together your agreement, how do you think about this 20 years removed? A good decision, good ways, things go well for you. And if you went to litigation, they ask the same questions. 20 years removed, it's like night and day. Those people that mediated, those people that had a hand, had a notion of, yes, I'm going to give and take, I'm going to negotiate for this. We sat before a mediator, we worked things out at the same table, we came to agreements. They are more complacent with how time has evolved and where they are. They feel better about where they were because they had skin in the game and they were able to participate. Whereas the people who litigated will often give back answers like, I had a bad attorney. I had a terrible judge. I had a case right in front of me that made my case seem like domestic violence light. I had facts that I couldn't put into court. I had evidence which was so good, but it was ruled inadmissible for reasons or that. There's so many things that can happen in litigation that are just evil and bad news and unfair. But in the context of mediation, where people have a right to speak here in the same room and nothing out of mediation leaves mediation, you can learn something that you can't take it back to the judge and say, well, they said in mediation. The judge will say, no, I can't hear anything. What happened in mediation stays in mediation. It helps. It helps to solve cases. So keep in mind that that is hands down the best way to get things done. Your rights to go before the court are there. And people, when they need to avail of that, know that they can, it's there for you. Courts are there for you. And it's a long line of both statutory law and case law that California has developed to try to help people out with all the various in between areas where the law has forgotten something. But by and large, in mediation, everything can be talked about. Everything from who else can be there at exchanges. Maybe I don't want your sister-in-law or your brother-in-law or somebody or your next door, all sorts of things can be put into writing where a judge would say, I'm not touching that. I'm not touching it with a 10-foot pole. But in mediation, you can say, well, my spouse knows that these things are important to me and that the ability to take the child, for example, to work is important for both of us, or something that, a judge might scoff at and say, that doesn't sound like good parenting. But if both parents are on board, you can put that into an agreement and come out with a much better termination of your divorce. Essentially, your marital settlement agreement should be and generally is significantly better if you mediate and have a hand in that process of the ultimate outcome. So I highly recommend it. Never, ever forget about the power of mediation within a family law context. Judges want it, and parties do too, anecdotally. They just don't know it yet.
Thank you all so much.
Thank you, thank you. Thank you everyone for joining us today. I'm just going to summarize a couple of documents that Jesus mentioned. I'm just going to let me see. I'm going to share my screen. Just to give folks an idea of the forms he has brought up. Let's see. Screen. Okay, here you go. Can everyone see my screen? Awesome. This is one of the forms Jesus mentioned, the FL 141, the FL 170, and the FL 300. And I think the last question I have, Jesus, before we transition out, a lot of these forms might feel a little overwhelming for folks. What are some recommendation or advice you can give them in regards to forms and documentations needing to submit when starting this process of divorce or legal separation?
Maritza, it's true that the forms look kind of complex, but they've been through so many iterations that and they have the best of the best attorneys who try to redraft them and try to make them so that they're as simple as possible, so that any person without an attorney could possibly go through it and just sort of paint by numbers and figure out, what is it, the basic things that they're asking for. So I agree with, I like the forms much more now than I did 25 years ago. That's for sure. There's been a real effort to make sure that even people without attorneys are not going to be misinterpret the forms. So they've gone over it and tried to make it as simple and clear as possible. Having said that, it could still behoove anybody, that I would care about. I would not want to send them into a court without uh, referring them to an attorney that I cared about, that I thought was trustworthy, because the matters are just so important that you don't want to, make an error that is very simple. So it's always good to have legal advice, even if it's private legal advice. You can handle a case just like you could in civil courts, in pro per, without an attorney, and then have a ghost attorney just evaluate things that you're doing. There's no rule against that. And you can always take, your private document before you actually sign off on it. Go and talk to an attorney, pay for a 1 hour consultation and say, well, what do you think about this? How I've done this to represent myself. They should give you a fair analysis as to whether or not you're doing fine on your own, or it might behoove you to hire an attorney and do it with a little bit more difficulty. But it's a great question.
Yeah, no, I thank you.
The forms aren't necessarily that easy to follow along, but they try to make, they really do, particularly the domestic violence ones. They're a lot better than they used to be.
No, I appreciate that. I appreciate the fact that you bring a lot of reassurance. You're very detailed and in your explanations. Um, for folks who eventually take the time to, watch this video, definitely take the time to pause, replay. If anything, um, for future services, we'll definitely connect you all with our amazing UCLA legal team here. Thank you so much, everyone, for watching this. And I'll put stop on the recording.